Hello, my name is Hani Bushra. I'm an immigration attorney in Huntington Beach, California, and today is February 3rd, 2023. And this is a video about the new guidance that was given by USCIS about when people who have been granted asylum or people who are admitted as refugees inside the United States could apply for the green card. Now, yesterday, the USCIS issued a clarification regarding their policy on when you can apply for a green card if you already have approved asylum or you were admitted as a refugee. Remember, you become a refugee not when your case is approved overseas, but it's when you actually enter the United States. That's when you became a refugee. Before this guidance, the law was that you would apply 1 year, from the approval of your asylum case or when you're admitted as a refugee. So let's say you were approved on January 1st, 2023, you would have to wait for 1 year and apply on January 1st, 2024, so you can go ahead and apply for the green card. Now, this 1 year had to be physical presence inside the United States. So if you had traveled anywhere during this 1 year, let's say you traveled for 10 days, you would have to make up those 10 days later on, when you apply for the green card. Now, before we get into the new guidance, before we can deal with anything about the new guidance, I want to define two words that are very important here, because these two words are going to play a very crucial role in understanding the new guidance. The first word is the word filing of an application, and the second word is called adjudication. The filing of an application is the event or the process by which you send an application and USCIS receives it in its mail room, and stamps that it has received it. At that point, the application is filed. It doesn't mean it has been looked into it hasn't been adjudicated or looked or decided on or anything like that. The other word is the word adjudicated, which is the word that is key to understanding the new guidance, and it's in the new guidance. Adjudicated means that it's when USCIS has issued a decision regarding the case, whether it's an approval or a denial. Now, adjudication can happen either after an interview or before an interview. Let's say they are deciding not to do interviews for people who are applying for green cards based on something, They can adjudicate the case without even having an interview, but they could also adjudicate the case in an interview or after an interview. Now, as lawyers, you guys know we live and die by words, Even my kids I have 4 kids and they go crazy when I keep asking, do you actually mean this word and the meaning of this word? Do you know what this word means? So it's very important for us to understand that the precise meaning is important in this process right now. Now, the new guidance makes it very, very clear, that you must be physically present in the United States for 1 year when the application is adjudicated. So you have to be in the United States when the application is decided. That is different than before, where it was, that it was 1 year from when the application was filed. Why are they doing this change? Is it a new law? It's not a new law, but they are actually interpreting the law correctly. For the longest time ever, they were misinterpreting the law, They also made it clear that only physical presence in the United States counts, meaning that you have to be in the United States for 1 year. Finally, they also made it clear, that an officer who's gonna look at the case and he doesn't see you have the 1 year present has to ask you, and demand from you proof that you actually were present for the 1 year. And this part about mandating that officers ask you, when officers ask for something, it's called a request for evidence. Mandating that, that change, or that demand towards the officer is going to be very important in talking about the strategies of how to deal with this. So what does this mean basically for us? Technically, it means you can apply right after you're approved for asylum. But if you're going to do that, you better be praying and hoping to God, that the officer does not adjudicate this case or decide your case before you had already accrued or you have the 1 year of actual physical presence in the United States. Essentially, you have to guess. Oh, I'm guessing that it's going to take them this long. And it's a little bit hard to do that. In our office, we handle hundreds and hundreds of green card applications and asylum cases every year. And when we do that, we see some discrepancies in approvals. We've seen some people get approved for the green card adjustment within 3 months to 6 months from their application time. Others have waited for a year or maybe longer than a year. So there has been discrepancy. So when you apply early than the 1 year filing that we used to have, date of filing, you are taking a risk, or you're trying to guess basically how long USCIS is going to take to process your case. Now, okay, the other thing, okay, is you got to understand that if the officer is looking into your case and he finds that you have not accrued that 1 year and you cannot prove that accrued the 1 year, so let's say you applied, let's say you got approved today for an asylum case, you decided to apply tomorrow, and when you apply tomorrow, okay, the officer looks at it after 6 months from today. And when he looks after 6 months from today, what does he do? He looks and says, you don't have the 1 year. Let me ask them if they can prove to me that I've been here physically present for 1 year. Remember, the 1 year counts after the asylum was approved. Okay, just make sure you understand that. So he sends you a request for evidence. The request for evidence says, prove to me that you were here for 1 year after the asylum was approved. You're not going to be able to do that. Because even if he sends you a request for evidence and it takes time to give you the response back, and he gives you like 90 days to respond back, 6 months plus 90 days. Remember, we said you applied immediately after you were approved. He issued the request for evidence 6 months after that. 6 months plus 3 months, which is the time given to you for you to respond to the request for evidence, is 9 months. So you don't have the 1 year. Okay. So what strategies are we going to be doing, at least in my office? Okay, and this is just my advice to you, and this is going to be my advice to my clients. Okay, the strategy that I feel very comfortable with is to apply at the 6 month mark. Okay, instead of waiting a whole year for the after the approval from asylum or from your entry as a refugee to apply for the green card, I would wait for 6 months and apply in the 6 month mark. And the reason I'm saying 6 months is just not haphazardly like that. It's based on two things. Number one is, like I said, based on the trends that I see on how long it's taking cases to be adjudicated or decided by the average time it's taking cases to be adjudicated by USCIS. And it's also based on the strategy of using the request for evidence to our advantage once it's issued, in case we don't have enough time. Remember, I talked to you that one of the requirements of the new policy is what? Is that if you are an officer and you don't have proof in front of you that this person has been here for 1 year since their asylum has been approved, you are required to ask for them to prove to you this now. Okay, that is called a request for evidence, and it can take 3 months to happen. So the way I'm strategizing is, if I can wait till 6 months to apply and then I apply, by the time it gets to an officer, let's say everything is just going super fast. Okay. It takes another 3 months to get to an officer. He sends me a request for evidence, proof to me that you stayed in the United States for 1 year, and that request gives me 90 days. I'm going to hold on to that request for evidence and send it at the very last minute to make sure that I have the 1 year accrued. The idea is, if you don't do that, if you don't have the 1 year accrued, it's going to get denied, and all the money you paid and the time you were waiting for the case is going to be wasted. Now, what could go wrong? I've been doing this for 15 years now, and a lot can go wrong with USCIS. I've been to almost every single USCIS office in the United States. There's a map in the side, you don't see it right now next to me, but it has the states, and I can say that almost 90% of the offices I've been there. So my experience with the USCIS is long, and a lot of things can go wrong. Let's just put it that way. Number one, you gotta understand that USCIS has thousands of officers, and some of those officers are been there for years and years and years. Some of those officers have been there for years. They rely only on their experiences, and when they rely only on their experiences in the past, sometimes they ignore new things that came up. They don't understand it, they don't read it, and they don't go with it. And so the idea is, let's just say you send in your green card application 2 weeks after you were approved, okay? And that green card application stayed with USCIS for 1.5 years. If you end up with an officer who doesn't know these new guidance and these new rules, he can look into that and say, oh yeah, he only fined 2 weeks. It should be 1 year filing. That's his old rule. That's how he's been trained for many, many years. He's been doing it for many, many years. He'll deny your case. You say it's not fair. I can appeal it. Yes, you could appeal it, but you're wasting your time. Okay? So you're wasting time, resources. Okay, you already waited 1 year on something, okay, to get the result, which is going to be a denial, and then you're going to waste another time to appeal. And most likely, actually, you're not going to appeal, you're going to refile again. So the number one problem I'm worried about personally, okay, Actually, this is the second problem. The first problem is I'm worried about people applying way early and they don't have enough time to accrue the 1 year, okay? But the second problem that I'm kind of worried about personally is officers who don't know the new guidance and they issue a rash decision, and that way you end up wasting a lot of time. And hopefully that will be corrected as it comes along, but it could happen. I'm just warning you that there's something that's could happen, okay? The second problem, or the third problem that I'm also anticipating, is in the use of the word adjudicate. Some officers might want to say that the word adjudicate does not mean actually a ruling. It means when I start handling your file. So they also acknowledge that filing is different than adjudication. So they say filing date is when we receive the application. That's fine. They say we're not going to look at that. Adjudication date is when I hold the file in my hands and start processing it. So let's just say, again, an example, you got accepted for asylum. You filed immediately for a green card, and after 11 months of waiting, the officer looks at your file and says, "Oh, it doesn't have the 1 year. Let him prove it for me." Then we send them a request for evidence to ask to him to prove that he's been here for 1 year. So he sends you that. You wait another month and a half to send it back to him. So now you have 13 months, okay, of total. You've passed based on the definition we talked about. You've passed. You already exceeded 1 year of presence in the United States. But this officer says, no, the way I define adjudication is when I handled the case in my own hand, okay? And I'm dealing with it in my own hand. And so it's at the 11-month point that we talked about, okay? This is a scenario that I don't see a lot is gonna happen, but it could happen, and it's something just I want you to be aware of and could be an issue that can come up. My advice, proceed with caution. Understand there is risks. Try not to be overly, I don't use the word greedy, okay? But just jumping the gun. Try to mitigate your risk. Try to take a calculated position where you make sure that you're not 100% waiting for the whole year or immediately applying after you get approved for asylum. Second, apply with a lawyer who knows how to fight back with USCIS, how to argue with USCIS, how to put this in their cover letter. I sat this morning changing our cover letters and making sure that our cover letters indicate this new change of policy and explaining it to the officers in case we fall with an officer who doesn't or is not aware of this new change of policy, okay? Thank you again for watching. Please keep following our channel. We'll definitely post videos regarding USCIS all the time. Thank you and have a wonderful day.